This month, Idaho Attorney General Raul Labrador, alongside 25 other Republican attorneys general, filed an amicus brief supporting President Trump's executive order mandating that federal inmates be housed according to their actual sex and halting federal funding for so-called gender-affirming procedures for prisoners. This action responds to federal judges blocking the order, citing Eighth Amendment concerns. The AGs argue that housing male prisoners with females endangers women's safety and infringes upon their rights to privacy and dignity. They assert that the federal government has the authority to make housing decisions that prioritize the well-being of all inmates. Joining us now is Idaho Attorney General Raul Labrador himself. General, it's so good to have you on. Thank you for joining us.
Thanks for having me. It's a pleasure to be on your show.
You know, the ACLU and all these civil liberties union groups, they have predictable positions on this. They will argue that in light of protecting the civil rights of, gender-confused people, you need to just drop this case.
You know, it's been amazing with the Trump administration that they finally brought back common sense to jurisprudence, common sense to the American people. And I think this is an 80-20 issue. Every time you look at this issue on polls, on anything, putting a man in a woman's prison where many of these women have been abused, many of these women have been in jeopardy. They have had very rough lives. Those are some of the things that lead them to crime and other things. And to put a gender-confused male in their prisons, who many times might even be a sexual predator or sexual offender themselves, is one of the most ridiculous things that I think our government has done. And it's one of the most ridiculous things that the courts are doing, is to actually rule in favor of these gender-confused individuals. So I'm proud to be leading a coalition of 26 other states that are fighting along with the Trump administration to ensure that these federal officers have the ability to make these decisions for the safety of the inmate population.
So I'm unclear as to the exact gist of the argument that's being made on the other side from the judges' perspectives. They're citing Eighth Amendment reasons. What is their strongest argument here, legally?
So their strongest argument is there's a long line of jurisprudence that talks about when inmates need any kind of medicine or medical treatment, that medical treatment refusing to provide the medical treatment actually leads to Eighth Amendment concerns. And there's a long line of cases dealing with that. But in this case, the question is what kind of treatment, what is exactly the treatment that is needed, and what exactly should the federal government be providing for them? That's number one when it comes to the treatment. The other line of issues is a little bit more difficult for me to understand, where the ACLU and other groups are coming from, to actually force the federal government to put a male in a woman's prison is clearly endangering the lives and the safety of women in those facilities.
So the next steps for your office and the coalition is what? How do you plan to either, I guess, oversee add to the amicus brief, or just wait for the court date? What are we looking towards next in this issue?
So there's a hearing that's going to be held in the D.C. Circuit Court, and after that hearing, hopefully they will rule in our favor. I think our arguments and the arguments of the Trump administration make a lot of sense, and hopefully they will use the law and common sense to make a decision. But if they rule against us, this is going to be a decision that's going to have to be made by the U.S. Supreme Court, and we will be leading that coalition again, making sure that we have a brief and the right information given to the U.S. Supreme Court, where I think this issue will probably be ultimately decided.
Very interesting. I mean, again, these are core constitutional issues, and when you bring up the other side's argument, the cruel and unusual punishment argument seems to be able to equally apply to the women who are kind of stuck in these positions and being imposed upon by this situation.
That's the thing, is that they're looking out for one person who clearly could be treated in different ways. There are ways to deal with that one individual instead of the hundreds of women that are probably going to be in those facilities with the one individual where their safety and their protection is not going to be as easily ensured if you have a male in those facilities. I just think this is one of the issues that 10 years ago anybody would have thought that it was ridiculous for any court or any public servant to be making the ridiculous argument that you should be allowing a man in a woman's prison.
You know, another topic I wanted to address with you, you are also bringing an amicus brief urging the U.S. Supreme Court to overturn Hawaii's sweeping public carry ban, arguing it violates the Second Amendment and it conflicts with the court's precedent in Bruin. This is a hallmark Supreme Court case on the Second Amendment. How does your coalition plan to address the circuit split here between the Second and the Ninth Circuits regarding this public carry law and some of the implications this might have for national security or for Second Amendment jurisprudence? This case is so funny because I know that the original Supreme Court case in Hawaii, one of their reasons for imposing this ridiculous ban was it was not cohesive with the spirit of aloha.
Well, Bruin, as you know, held that all individuals have a Second Amendment right, that they can carry weapons as long as they're not on private property that is forbidding that. If they're in the public, that governments cannot forbid that from happening. What Hawaii did is they actually were pretty crafty in what they did is they turned it on its head. What they did is they forbade anyone from carrying weapons in public unless there's specific guidance telling them that they can't carry the weapons. So instead of telling businesses you can, what Bruin allows that a business can say you're not allowed to carry a weapon on our property, the Hawaii legislature, what they did is they said you're not allowed to carry it unless the owner or the government specifically gives you permission. And that's completely turning Bruin on its head. The Second Circuit already ruled against a similar statute. And the Ninth Circuit, of course, which is the most liberal circuit in the land, they decided to side with Hawaii. And I think there's a circuit split. And I believe the court's going to take this up. And I think the U.S. Supreme Court's going to overturn this.
You know, in reading or glancing through, I didn't have time to read the whole thing, but in glancing through that Supreme Court, the Hawaiian Supreme Court ruling on this, the gymnastics that they had to undergo, the logical gymnastics that they used was not testament to their legal prowess. I think they've been sitting on the beaches a little more than they've been working in the back rooms with the clerks.
Well, sometimes those legal gymnastics do tell you that they've spent a lot of time trying to justify something that is unjustifiable, trying to figure out how to get around a U.S. Supreme Court decision that is so clear. The U.S. Supreme Court could not have been more clear, but that's why you pay a lot of money to attorneys to come up with these novel concepts, and the Supreme Court in Hawaii is obviously a liberal court. The Ninth Circuit's a liberal court, and they're going to try to do everything they can to impede and to take away some of the protections of the Second Amendment. So that's why this coalition of attorneys general that is being led by us in Idaho is just so adamant that we need to have the Supreme Court take up this case and to overturn what the Hawaii Supreme Court did.
I like to remind our audience frequently that we are currently in a really fascinating moment legally. We have the most Republican attorneys general of any time in history, I think. Something like a little more than half of all the states are now run by a Republican attorneys general. And that is going to have noticeable effects in how the president's mission is carried out, but also how the Constitution will we will set the tone going forward in ensuring that some core issues in the Constitution are going to be maintained.
Absolutely. We have a strong coalition of Republican attorneys general. We work very closely together, but don't be misled. The Democrats are doing the same thing. They have what they call tiger teams where they work together, and they have a bunch of large law firms, multinational law firms that are working every day to undermine what the Trump administration is doing. And that's why we're working so hard with our coalition to ensure that what the people voted for, what the American public wanted, that we can fight for in the courts. And that's one of the duties of all Republican attorneys general, and we'll continue to do that.
General Raul Labrador out of Idaho, the great state of Idaho. Thank you very much for joining us and making the time.
Thank you so much.
Coming up, Dr. Jim Thorpe in studio to tell us what he told Congress earlier this week. Shocking revelations about the jab. You won't want to miss this. We'll be right back.